Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. In today's video, we're going to talk about the most recent immigration news. We're going to cover new rules for young immigrants that Department of Homeland Security is proposing. We're going to talk about USCIS extending deadlines for deadlines to answer to certain notices that you may receive if you are in the USCIS proceedings. And we're also going to cover some other local news related to detention, for example, in New York, New Jersey. And thank you very much for joining me. If you're here for the first time, welcome. Please subscribe to my channel, like, share this video, and let's start. First of all, we're going to cover USCIS extending again deadlines to respond to their notices. Notice of intent to revoke or rescind, notice for request for more evidence, for example, or the deadline for you to file a motion to reopen or reconsider or an appeal. Consistent with its policy during COVID times, USCIS once again extends flexibility in responding to these notices for the beneficiaries or people who are applying for benefits. You're again going to have more time to submit your responses to USCIS. Depending on what you received, you're either going to receive 60 more days or 30 more days. However, interestingly enough, the documents that you receive from USCIS contain original, not automatically extended deadlines. Remember this. So when you receive, for example, a request for more evidence and it says, let's say, the deadline for you to respond to it would be December 31st, 2021. It means that you're going to receive extra time from December 31st, 2021 past that time. So it will be January, February, end of February, right? Or because February is a short month, you're going to receive extra 60 days. It's going to be actually March 1st or so. So it's very important to remember. It gives you peace of mind if you would like to take a little bit more time responding on requests for more evidence, for example, in connection with the income or a fee, request for more evidence to show that you can sponsor somebody, or you're going to have, let's say, 30 more days to file something as important as motion to reopen or an appeal. And trust me, when you are dealing with motions to reopen or appeal, you usually need that extra time. So this extension is going to cover various requests that government is sending you in connection with immigration benefits if they're dated from March 1st, 2020 through January 15th, 2022. Through January 15th, 2022. After January 15th, 2022, it's either that USCIS one more time will extend the flexibility, or you will have to rely on the original deadlines containing in those notices that you receive. Very important. Now let's talk about the big news. DACA is going to be hopefully saved by Department of Homeland Security. They just introduced formal rules, 205 pages of rules codifying DACA. It's supposed to help to overcome concerns that appeared when the federal judge in Texas ruled that DACA was based on a ruling that essentially was not following the necessary steps. And when the DACA was established, the government did not seek necessary public feedback, and hence the program was illegal. So this introduced ruling of regulations should resolve this issue. The good thing that it's going to help people who are already qualifying for DACA, those who are seeking to file for it for the first time, or those who are going to be renewing it and so on. But the program did not move the deadlines. This proposed new regulation did not move the deadlines for qualifications. still it is required for you to qualify for DACA. You have to show that you've been residing in the United States since 2007 and physically present in the United States since 2012, and so on and so forth. All old qualifications for DACA remain. The rule clarifies some points. For example, it codifies the fact that when you have DACA, it means you are lawfully present in the United States and you're not accumulating unlawful presence anymore. It also says that employment authorization is optional, and you may not want to file for it. You don't have to, but then you're not going to get it. And they're going to restructure the fees a little bit. Now they're going to always charge $85 for biometrics, regardless if you file for employment or not. They're attaching that fee to the form, DACA form, rather than to your employment authorization. So it tweaks different things a little bit. Of course, it provides the basis for the rule. It seeks public comment. And again, it means that hopefully the concerns that the judge expressed, the federal judge who stated that the program was unlawful, will be overcome, and hence new applications that now can be filed but not granted should be granted after the process will be finished. So it's very good news. We finally see proactive government action to help, at least to make the rules better, to help people who are afraid that their status may be lost. Hopefully they're going to do the same for other groups of immigrants, and perhaps will, for example, redesignate countries like El Salvador for TPS, not just extend it automatically, and so on and so forth. We will see. But right now, I think it's a good rule, especially for those who may potentially file for DACA for the first time. Again, qualifications did not change. And those who are renewing the applications, they're allowed to renew right now. And hopefully they're going to have peace of mind that everything will be fine. And now we're going to finish our presentation with a couple of local updates. Well, first of all, interestingly, Hudson Jail. If you ever been in removal proceedings and perhaps you were detained, very often people from New York have to be in detention in Hudson Jail. It terminated its contract with ICE, and starting from November 1st, Hudson Jail is no longer going to host ICE-related detainees. I'm not sure where people are going to be kept, but not in Hudson, it seems. You know, maybe it's good to know. Maybe if somebody who you know is currently in that facility, they probably will have to be transferred, right? Will have to be transferred. Hopefully not to some remote location like Louisiana, but you never know. Also, interestingly enough, Broadway Immigration Court at 290 Broadway is going to have their master hearings telephonically. This was the standing order that was issued, I think, a week or two ago. And now you, a person, would not have to appear if your hearing is in fact telephonically held. Only your attorney for master hearings. Okay? So if you are scheduled to appear for a master hearing at 290 Broadway in New York, check with your lawyer as to whether or not you need to physically come to court. I think the lawyer is going to tell you that no, you don't need to. The lawyer is going to handle that matter on their own without you. So just technical update. It's good to know, and hopefully it's going to help some of you who are in removal proceedings. By the way, the hearings currently are going on. I've noticed that a lot of master hearings are being rescheduled, but individual hearings are not. And what's happening is that lawyer gets a notice that an individual hearing is going to be held via web conference on a very short notice before the hearing. So very often an attorney and the client are going to come to court together, ready for an in-person hearing, and then they receive news that the hearing is going to be done via video, and a judge is going to appear on a screen, and all the documents have to be handled to a clerk. Maybe somebody will find this information helpful. Thank you very much, guys, for watching. Stay on top of your immigration case. Follow me for more news. And if you are in removal proceedings, stay updated with regard to how and when you need to appear. It's very, very important. Also, if you have reasons with chances for, do not forget to ask your attorney to submit prosecutorial discretion. By the way, prosecutorial discretion is a very, very broad term. It contains a lot of different things that you can file for, from administratively closing the case to terminating the case to maybe agreeing on certain points for your case. All right, so you have to discuss this with your attorney, and prosecutorial discretion also can be granted by ICE officers, even though I believe they were under stay. Then what happened was that the court lifted the stay and so on and so forth. But on a case-by-case basis, if you have basis to ask for some leniency for yourself, always do that. Thank you very much, guys, and I hope to see you soon.